Mr. Holmes, let's go ahead and start. Read number 1.
Racketeering. Individuals involved in organized crime, any act or threat.
Okay. Give me an example.
Like a bank is being used to launder money through it because they're threatening people to pay them money monthly
Okay.
for protection.
Okay. What do you say, Mr.
I was gonna say the mob.
The mob?
The mob, years ago as well as today, I'm sure it's still happening, where they have a controlled situation where they're going in and they're expecting people to pay them for activities or, I'm trying to think of the word, moving money around,
Okay.
so to speak, for their benefit.
Okay.
But forcing the people to pay them for things that they don't need to pay for.
Okay. Does anyone have any questions about racketeering? You usually see this in a lot of your movies, this idea of running an organized crime unit or an enterprise, if you will. Does everyone have the same definition, relatively speaking? Yeah? Okay. The young one, Miss
Courtney.
That's what I want. Miss Courtney, read number 2.
Conspiracy requires any act in Florida. Do you want the definition?
That's the definition?
Do you want the definition?
Yeah.
Okay. It's the agreement between two or more people to commit an unlawful act or to use unlawful means to achieve an otherwise lawful result.
Okay, what I want you to know from my A people, are we listening? Is that common law in several other jurisdictions, to be convicted of conspiracy, it requires what we call an overt act, something substantial in furtherance. So if we agree to rob the bank, that would not be sufficient. We go and case the place, see how many guards are there. We pull up blueprints online for the purpose of seeing modes of escape. Those are acts in furtherance, substantial steps towards our criminal agreement. Okay, we're distinguishing that. In Florida, that is not the case. Okay, please share with your friends. If you are sitting in a room and they are discussing breaking the law, it takes very little effort to be part of the conspiracy in the state of Florida. Because by law, any act is what's necessary. Professor Moore, what do you mean? What I mean is we're talking about robbing the bank. I just Google online real quick just to see where it is. Then I changed my mind. Oh, that's crazy. I can't do this. What will Mama say?
You already Googled it.
I already Googled it. That is an act in furtherance of our criminal enterprise. At the time, we were very serious about robbing the bank, and I might do 10 years as a first-time offender. Are we listening? Share with friends. Okay? That's how people get caught up. They don't understand what the law says. Okay? Mind the company that you keep. Any act for my 8 people. That's all that's sufficient. Anything. We got it? I hope so. Yes.
Can you repeat the other definition?
Yes, at common law and in several other jurisdictions, including a federal law, what is required is an overt act, O-V-E-R-T. Overt means something substantial, okay? We didn't just agree to rob the bank, we went and bought weapons. That's overt. Okay? Something substantial in furtherance of our criminal agreement, our unlawful agreement. Okay? You cannot conspire alone, meaning there at least takes two. And all interested parties have to intend for the conspiracy, meaning it's an intentional act. Not by mistake. We're talking about robbing the bank because we're broke. We want money. Not accidental. No overt act is required in Florida. Any act. They have made it easier for the prosecution for the state. Please share this in the barbershop. Okay? Just feel like others should hear it, right? We agree. Number 3, due process. This is very important to me. Tell me your last name here. That's wrong. Ms. Dominguez, your hand was up, right? Ms. Dominguez, what say you? Due process.
Due process is a constitutional right to be heard, question witnesses, and present evidence before any criminal conviction can occur.
Okay, excellent. I want to add a lot to that because we might see it again. With respect to due process, we are specifically talking about the Fifth Amendment. Okay? As it relates to the states, we are also talking about the 14th Amendment. This notion, this idea of life, liberty, and property, protected interest. Okay, we did not reinvent the wheel. A lot of this language was lifted, if you will, for lack of a better word, straight from the Magna Carta, 1700s. Okay, no longer did we want a king to be able to say, off with your head. Now we have notice. In criminal law, we have an arraignment. We explain to you the charges against you. You can call someone and say, I'm still alive. Come get me. You can challenge in front of an objective tribunal, a jury of your peers, to say, I wasn't the guy who committed the crime. It wasn't me. I have a right to challenge the witnesses against me. Craig says I robbed the bank, I can put him on the stand and do what we call cross-examine. All of these ideas are due process. The government can take your property, but they need to notify you. Your taxes are in arrears. If you don't pay by such and such date, we will come back out here. Okay? Sheriff can put a lock on, seize the property inside, sell it towards the deficiency. But we give you notice. You have a time to cure it. All that's due process. We have it in civil and criminal law. Very important. Okay? Embezzlement. Did we get to number 4? No. I hope so. Ms. Woods, are you here?
Yes.
What do you say? Number 4.
Embezzlement is a statutory offense consisting of the unlawful conversion of property entrusted to the wrongdoer.
Okay, I want to add something to embezzlement. Are we listening?
Yes.
For purposes of embezzlement, you are typically looking at a professional actor. Professor Moore, I don't know what you mean. Let me explain. What I mean is a banker, a lawyer, an accountant, CPA, people who are entrusted, because embezzlement requires what we call lawful possession. And I want to give an example as simple as I can make it. Ms. Ross is my client. She gets in a car accident, car is totaled, we got $100,000 in medical bills. Does everyone follow me? When we sue the defendant, John Doe, we get a judgment from a jury for $100,000. And that's our recovery. Is everyone good so far? Yeah? According to our contingency agreement, I am entitled to 25%, to keep it very simple, of whatever comes out of the lawsuit. So in $100,000, I would be entitled to $25,000. Good, keep the math simple for me too. The problem is, once we deposit the money in trust, okay, the money goes into the attorney trust account, the client is paid out of trust funds, which the bar takes interest off of. I start thinking about Sue Ann. I know that she loves that purse that I wasn't able to buy. I am aware she loves to vacation. I'm under stress. And instead of taking my 25%, I take 50. What would I be asking you? What's the issue? What's the problem?
Did you, is it embezzlement?
It's embezzlement, but someone tell me why it's embezzlement.
Because you're spending money that's not yours and that somebody else entrusted you with.
Good, but I want you to go farther than that, Ms. Wright. For my A people, they would tell me this: Professor Moore, you had lawful possession of the money when it was initially deposited. I was not a thief when I initially deposited the client funds, because they should go in trust. I became a thief when I unlawfully converted more funds than which I was entitled to. Once I hit a penny over 25,000, my crime was vested. I embezzled. Now, I don't want to get too far ahead, but embezzlement is a type of theft. So is larceny. So is burglary. So is robbery. Some are with force, some aren't. I don't want to go too far too fast, but you get the idea. There are a lot of ways you can steal. I'm still a thief. We just classify it in different ways. Okay? The embezzlement occurred when I unlawfully converted more than what was mine. I misappropriated those funds. But initially, my possession of the $100,000 was lawful. Had I written her a check in trust for $75,000, like I was supposed to, I can do whatever I wanted with that $25,000 because that's my what? That's my money. You get it? Same with the bank. You know, you pay a broker X amount percent to buy stock for you. Any dime over that, they've embezzled. Because initially they had lawful possession of the money. Okay? The difference is if I'm just a thief, I never have lawful possession of the money. I just came and stole it. It was never appropriately in my possession. Yes?
Let's say if an employee is trusted with printing paper.
Absolutely. Employees. I work for Walmart. Busy day. It's the holidays. Trying to get that PlayStation for Junior. They won't miss this. I can ring it up, change the price. Who's gonna know? Camera's pointed the other way. When I take the money from the customers, I have lawful what? Possession. I work for Walmart. The embezzlement occurs when I unlawfully convert it to my personal use. Because none of it is supposed to go to me. Good point. Fifth Amendment. Did I skip extortion? I did. Number 5, extortion. Caroline.
The obtaining of property from another induced by wrongful use of actual or threatened force, violence, or fear for under color of official right.
Okay, I don't want to confuse extortion with other crimes. Say the last phrase again. Under what?
Color of official right.
Under color of official right. This is where you typically see someone who is law enforcement, Congress, some other official, typically, misusing their authority. Okay, I got a big vote up, I'm in Congress, on whether or not to approve some EPA rule. And a company that doesn't want me to approve it comes to my office. Professor Moore, you could be the swing vote on this committee. We really need your help. I sure do want to help. But Junior's in the 11th grade now. He's got to go to college. We got to figure out something. Okay? Remember what I said. There are a lot of ways you can steal. I am using the color of my office. That's what I'm doing. Okay? Cop whose lawful duty is to patrol and protect the community. Hey, we got wind a lot of drug dealers moved in. Things might get bad. I want to come by and help you, but, you know, what have you done for me lately? What's in it for me? Okay? Misuse. Color. Color of title, color of office. Fifth Amendment, number 6. Ms. Gaston.
Constitutional protection against self-incrimination also guarantees due process.
Okay, guarantees due process. Fifth Amendment, we talked a lot about it. The whole idea of the Arizona case, Miranda rights, has been read into the Fifth Amendment. This concept of when you get in a jam, i.e. arrested, in custody, close your mouth, share with friends. Do not say anything. And call Professor Moore or someone like me. Because the Constitution allows you to be quiet. Please share this. You'd be shocked how many people sit in the jailhouse help convict themselves. Just let me explain. Okay. All I was gonna do was get high. I didn't know they were gonna beat him up. When you were there, you came with them. He's in a coma. You placed yourself at the scene. You've admitted to a conspiracy. Just be quiet. Okay? Fifth Amendment. Live to fight another day. Get in the car and go. We got it? Hope so. Money laundering. Number 7, Mr. That's who I want.
Money laundering is financial transactions that are designed to disguise the source of funds resulting from illegal activities. One good example is a drug dealer who pays a restaurant owner a fee to deposit his drug dealing proceeds in the restaurant's account, and then pass it on to the drug dealer afterwards.
Money laundering is a very simple concept. It's really the concept of commingling dirty money, meaning money unlawfully earned, with legitimate business. So if I run my gambling enterprise off the books, I make $100 grand this year. I don't want the government involved with that because I can't show how I made this $100,000 because it wasn't legal. So I put it in my pizza shop. I put it in my barber shop. I put it in my car wash and commingle it with legitimate business, money laundering. I'm evading the government.
Like Breaking Bad.
All right, number 8, doing well. Mr. Jim, that's who I want, number 8.
Number 8, Sixth Amendment. In all criminal prosecutions, the accused shall enjoy the right up to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, and to have compulsory process for obtaining witnesses in his favor and have the assistance of counsel for his defense.
Good. Sixth Amendment is in essence a way of having due process, if you will. This idea of impartiality. Okay, not a jury that's the former classmates of the prosecutor or the judge. We try to eliminate bias. Okay, a jury of the community, of our quote peers. This notion of speedy trial. The idea of the government not accusing you of crime and locking you away for a year and a half till we get ready to decide if we're going to prosecute you. The state has a certain amount of time. Once that time has lapsed, they have to do something, we'll let you go. Okay. Yes?
Let's say the government suspects somebody is involved in terrorist activities. And the federal government arrests that person and then say that they will be kept at Guantanamo. Can Florida file a lawsuit against the government to stop them from doing that? Because the person was a Florida citizen.
No, Florida wouldn't have a standing to do it. The state has not suffered an injury. The person could file a lawsuit against the government to the extent they're not sovereign immune and challenge their detention. I don't want to get political, especially not on tape, but I will say this is a very serious issue we're wrestling with respect to Guantanamo still being open. Okay, because this classification of enemy combatants, this idea of people taken off of foreign soil who may or may not be United States citizens, meaning in some instances at least, the Constitution carte blanche applies. How then do you reason this? Okay, that's as far as I want to go. All right, number 9, perjury. Miss, tell me your last name here. Ma'am, what's your last name? Knight?
No, Brandon.
Obrego? Okay, that's what I want.
The crime of intentionally lying after being duly sworn to tell the truth by a notary, public, or clerk or other official.
Keep going.
This false statement may be made in testimony in court, administrative hearings, depositions, answers to interrogatories, as well as by citing or acknowledging a written legal document known to contain false information. Although it is a crime, prosecution for perjury are rare because the defendant will argue he or she merely made a mistake or misunderstood.
Okay, excellent. Professor Moore loves reminding people that they're under oath when I question them, deposition in court. Before you answer, let me just make sure you know. For fear of perjury, you must tell me the truth. Okay? Whole truth. This also ties in with the Fifth Amendment and your right to not self-incriminate. Okay? You do not have to, quote, tell me the truth if the truth implicates criminal culpability. We have created an exception. But for that instance, almost certainly, you need to answer the question. Okay? If it looks bad on you or something you didn't want known, you deal with that later. Okay? Perjury is real. Okay? It's a crime that goes against your character. You are intending to deceive and or be dishonest. It's better to say nothing than to lie under oath. Fourth Amendment. Man, I care a whole lot about this, so let's make sure we get it down. Mr. Tell me your last name here. I got hands everywhere. Huh?
Prevalon.
That's what I want. Mr. Prevalon, what do you say? I have no idea what this is. They told me you could help me.
Fourth Amendment is the right of the people to be secure in their persons, houses, papers, and effect against unreasonable searches and seizures.
Okay. What about my exceptions? They're right here. Let's read them.
Oh, warrant.
What's the second?
A government agency can seize the property of individuals if they obtain a search warrant issued by a judge or a magistrate.
Okay. Is there a second exception? What is that? Okay, and what's the third? Can we read this out loud?
Articulate suspicion. Activities.
Okay, I want to take this one at a time because I care a lot about it. First, if the government has a warrant, please get out of the way or you will be moved out of the way. Because what the warrant means in essence, they have already gone before an objective tribunal or judge and explained and articulated the reasons in which they need to search you and shown their reasonableness. Okay, whether you agree or disagree with that, you need to step aside. Okay? Warrant is the highest level of protection for law enforcement because they have to go to a judge to secure it. The judge in kind can say you don't have enough information. Keep working on it. Doesn't mean the judge automatically signs the warrant. So this is in theory a check on law enforcement. They don't get the warrant because they think you're a bad guy. Show me the evidence. What do you have? Okay. Probable cause. This is our intermediary level in which law enforcement can lawfully search and or seize. Okay, I'm going to give you a couple of examples that helped me in law school. Sensory. If I can see it, I can smell it, I can touch it. Probable. It is more probable than not that a crime is being committed or has been committed. Professor Moore, I'm lost. Don't worry. You and your friends are driving. Okay. All the young folks, we still here? Okay. And one of you all is high out of the four of you in the car. Just one. And I stop you, let's say law enforcement, because a back tail light is out. Lawful stop? Absolutely. No feel. No emotion. And upon getting to the car, I get hit with what? A fresh smell, marijuana, weed, cannabis, whatever you want to call it. I immediately order everyone out of the car search everyone and the car. Can I do it?
Yeah.
Yeah, probably so.
Good. Glad you guys are on the same page of the law. I've debated this with students for some reason. Oh, Professor Moore, but I wasn't high. And your point would be, probable cause is not about establishing guilt. Because of the smell emitting from the vehicle, you are in the vehicle. It is not possible in many instances for me to tell who was smoking, but I know someone was and that the substance is illegal. Let's all go downtown. Share with friends. We here? Don't want to offend, just putting it out. We're just learning. I know this doesn't apply to any of you. I know this. I know it wouldn't be anyone in my Okay. Probable cause. Okay, I want to give another example. You are standing on the sidewalk, minding your business. I'm a cop just on patrol, and I see what reasonably appears to be a weapon. Upon further glance, I see just a little bit of the black handle, appears to be a handgun from my experience, coming out of your pocket. Can I stop and search you? Absolutely. Absolutely. I have cause to ensure, A, the safety of the public, B, that you have a lawful right to carry that weapon. Okay, it doesn't mean you go to jail, doesn't mean a crime was committed. Okay, we're just talking about search, stop. Okay, it is more probable. I want to give you a more controversial example, it's concrete. I stop you all again with the taillight out. I can't smell anything, I'm just going to write you a warning ticket. But I let Fluffy out the car. Fluffy is my what?
Dog.
Dog, my canine, part of the unit. Fluffy is trained, and can smell 90 times that of a human being, and can recognize contraband in 99-point-something% of situations. I don't smell a thing. But as soon as I get ready to hand the ticket and walk back to the car and leave, Fluffy, what? Oh. Fluffy goes crazy. Smell something. Passenger side, back door, on the left side. I order everyone out. Search the vehicle. Can I do it?
Yes.
Absolutely. Please share with friends. My A people will understand that I did not unlawfully search you because I didn't order you out and conduct a search until what? Until Fluffy started barking. Had I done so prematurely, when I just stopped you because the back tail light was out, that's unconstitutional. I can articulate a subsequent reason why I searched the vehicle. Not why I stopped it, why I searched it. Because it was more probable than not that drugs, unlawful contraband, are in the car or were or what we call residue. I have a reason that's objective. Gang, please don't feel. I know this touches a nerve. I just want you all to understand what the law says, okay? Yes.
If there, for example, if there was no scent in the vehicle.
Wait, mister, take those out.
I'm sorry. If there was no scent in the vehicle, how would you dispute that in court?
You'd have a tough time.
The dog
Because
smell,
the
yeah,
dog-
he's an officer.
I'm not saying the dog smell anything. I'm just saying for officers say he smells something
Yeah,
just to search the vehicle.
Oh.
Without there's no scent in there at all, knowing that there's no smell in there.
Well,
How would you argue that?
let me explain. That's a good question. Because we do get into circumstances, and I don't want to begrudge law enforcement because they do a job I wouldn't do. I want to show them their respect, especially on tape. I will say law enforcement officers are human, like the rest of us, meaning we all have flaws, right? And so most oftentimes, if not always, there is a dash cam, a tape, a video and audio that is running when they stop a vehicle. It's not just for your protection, it's for the cop's protection. So he or she can show why they did what they did and were hopefully following the law. It would just depend on the situation. I would tell you that's very dangerous for a cop to just ad hoc say I smelled something and I didn't for the purpose of conducting a search. You do that too many times, you're gonna have a problem. Okay. Yes?
Can police officers hold it? Like, let's say until the dog comes in, whatever?
Yeah,
They can?
of course.
Why is that though?
Because it's not unreasonable. Once I have a lawful stop, go back to my example. I have a lawful stop because your back tail light is out. Even if you didn't know, you knew or should have known. You're driving. To the extent we wait 20 minutes for Fluffy to come and walk around the car, that is not unreasonable under common law today. Now, what unreasonable would be, i.e. unconstitutional, Fluffy walks around, doesn't smell anything, doesn't bark, and we sit there another 30 minutes. Then you got a problem. But we wait for Fluffy to come, we gotta sit with him. I know y'all up to something, let me get my man out the back. That's what you got. It's not unconstitutional. No one has entered that vehicle until that dog went crazy. Okay? Real quick.
I know this class is based on feelings, but you know, in regards to the probable cause and searching the vehicles, you know, I clearly can say that that's a rule that's rarely followed by law enforcement. I mean, because they have sometimes stops where they just begin. I mean, I've been searched on numerous occasions because you know all of my vehicles have very dark tints on it, but I don't smoke or anything like that, but it still gets searched. So
let me say this about lawful stops. For purposes of stopping, okay, the Supreme Court has made clear, if it's 4th of July, or we've had an upswing in DUIs or something that is happening in the community, law enforcement can set up random stops. It is lawful to do that if, to your point, if they follow a formula, meaning they stop every car that comes through or every third car. If I see you and your boys and I just stopped a car, I can't just decide to stop it on a whim. That's unconstitutional. If I'm following every third car because it's 4th of July, we have a heightened interest to keep the community safe, and that happens to be you and your boys in the third car, that's a lawful stop. That's what they said. Okay? But it has to be formulaic. It can't just be, oh, wait, no, they look funny. Let's get them over here. Okay? If they're the third car, just like all the rest of the third cars, then so be it. All right, last one, real quick.
So they're allowed to stop you for the tents?
If it's dark.
Yeah, well, there may be an ordinance about the tents.
It's a law.
And if they can't tell if it's too dark, that's a lawful stop.
If
They're
they
deciding
can't
for
see
laws
the
to be broken.
headlights, it's too dark.
Okay. All right, last one, articulable suspicion. I want to make sure we understand this last one. This is the least protected way in which law enforcement can stop you, the lowest threshold, if you will. Okay, let me give you one classic example of articulable suspicion that criminal activity is afoot. Notice of all of the questions I gave you to define, I wrote out these 3 exceptions. That should not be lost on you. That's all I want to say. It's been there 5 days. We agree? Okay. So Professor Moore is walking down the street. Okay. Pants are low. We okay? Got my sag on. Okay. Trying to impress. Right. Fresh from the barbershop, earring hanging. You guys with me? Styling. Shoes untied, you can see it. Walking slow. And I see law enforcement on the corner. Soon as I see him, I jet. I gotta go. Well, they give what? They give chase. They stop me. We used to call it Terry pat down, Terry stop. Search me, find nothing. Tell me I can go. Has the law been broken? Just take a second and think. You could see something like this. We don't know.
Yes.
Okay. There must be one of these 3 reasons for law enforcement to stop and or search. I'm asking you, based on what I just said, you might be my attorney next week, or Wednesday, and I need to know if this stop was indeed lawful. Was it?
Yeah.
I want to hear from her in the back. She's been so patient. Tell me your last name here.
Santa Maria.
That's who I want, Miss Santa Maria. I saw your hand. That's perfect. What do you say about this, Miss Santa? I don't know.
I think it is lawful to.
Why?
Because he made a suspicious activity by going back. Like when he saw them, he just went back, and that made them like suspicious to think that he was doing something wrong or.
I agree with you. Okay, gang, are we here? It's you that's the problem. Too many times. Would a reasonable person see law enforcement and take off running? No, just keep about your way. Why are you looking funny, looking suspicious? Just be about your business. When you start running, I'm going to give chase. Because a reasonable, articulable thing, now, based on your conduct, that's suspicious. For you to see a uniformed officer and take off. Now, if I told you I was running already around the block, okay, so be it. But I didn't tell you that. I told you as soon as I what? Saw 5-0, I had to go. Okay? Even if I had drugs on me, it would be better if I kept what? Kept walking. Okay? Share. This crazy man's teaching me stuff today. Guess what I found out? Now, let me say something else for my A people. Notice, it had nothing to do with the fluff that I gave you in the beginning. My pants sagging, my earring, whether you agree or disagree with how I chose to express myself is not relevant to anything. Are we here? It has nothing to do with anything. I need you to understand that. I could have told you I had on a tie-dye and tattoos and an oval in my ear. It shouldn't mean a thing. Law has nothing to do with, that's an emotion. How you feel about the type of dress. Separate it. Because I may give you a picture that makes you feel like someone is a criminal and they have done nothing wrong. Okay, divorce yourself. Okay, check ourselves at the door. All right, how do we feel about this? I feel good. We good? Yeah? Okay. For the sake of time, I'm going to move forward, but I want to make sure we all answer questions 4, 9, and 14. Let me just see how long it takes this to do. All right, let's do it real quick, and then I want to get to one more thing before we run out of time. Gang, if you have your book, and my book is chapter 8, maybe chapter 9 or so in yours. I'm just going by mine. Excuse me. Turn to page 183. Over there? Yeah. It might be different in your book.
167.
167 in the other book. Okay. Is Miss Wright here? Is she here? Is Dominique Wright here? No. No? What's your last name?
James.
Oh, Miss James. James, that's who I want. I'm looking at you, Miss James. I'm thinking of right. So, Miss James, I saw your hand. Let me get you. Hey, you guys know how much I love volunteers. You know this. I saw Miss James. I don't want to ignore her. So let's go to number 4. Are we there?
Yeah, I'm there.
You know I appreciate you, Miss James. It means a lot to me. Go ahead and read that for me. It's just a few sentences there.
Girl drove her automobile after having had dinner and several drinks. She fell asleep at the wheel and ran over and killed a pedestrian. Prosecuted for manslaughter, she raised the defense that she did not intend to hurt anyone, and because of the drinks, did not know what she was doing. Was this a valid defense?
Okay, I know this has nothing to do with us. I know that. Okay, none of us have ever had too many and got in the car, I know. But for purposes of just an example, is it a valid defense?
No.
Why not?
Because, she didn't give valid defense based on the basis of criminal liability.
Okay,
The mental state or intent does not require an awareness or knowledge of guilt.
Right.
In most crimes, the voluntary commission of the act is sufficient for proving the mental state. Ignorance that the law is being broken does not mean there is not a mental state.
can you just read the last sentence for me slow? I just want to make sure that we process it. Say again about ignorance.
Ignorance that a law is being broken does not mean there is not a mental state.
So, if I say to my boys, man, I didn't know, does that mean anything?
No.
Okay, make sure we understand, because the law is codified, it is published, you knew or should have known. It was available to you. Law School 101, ignorance of the law is no defense. Okay, if the speed limit is 65 and I'm doing 65, and I didn't see it change down to 55, I'm still speeding. It's not predicated on whether I saw the sign change. Simple as that. Okay, good. Let me say one more thing. For purposes of manslaughter, okay, it's an idea of a gross and wanton act, is what driving under the influence is. It's extremely reckless, and it does not require you to intend anything. It's based on your behavior. If I'm twirling my gun right now in class, and I know it's loaded and the safety's off, I may not intend to shoot anybody. But if someone is shot, that's manslaughter. Because my conduct is so beyond the pale of what is reasonable under the circumstances. Okay? In Florida, driving a vehicle is like holding a shotgun.
Wow.
It is a dangerous instrumentality under the statute, and liability attaches. Okay, which is why if you try to hit a law enforcement officer when they're chasing you down, they're going to charge you with attempted murder.
Wow.
Because it's just like firing a shotgun. You could kill someone with the car. It weighs half a ton. That's simple. Okay. Yes, Ms. Wood.
My question was, with this case, in manslaughter, does that mean she actually does she have to go to jail? Like, how long, does manslaughter mean you have to go to jail for a certain amount?
I like the question, but I want you to go too far in the sentencing, because we take into a lot of different factors with respect to sentencing. It means that she could and is subject to going away, and in some instances for a long time. Okay, yes, sir.
The states change that law if they decide to have it the other way? Because
Specifically what? The
like,
intent?
No, like if someone claims like what happened in Texas, someone said that they were so rich that they didn't know any better, and they killed someone, so he got off early. He didn't get any jail time.
Well, I don't want you guys to confuse conviction with punishment, because they are two separate things. If someone is convicted for manslaughter and gets an extended probation, we might be upset about the sentencing, the probationary period, but they were still convicted. And so to piggyback on Ms. Woods' point, we take into account a number of issues, many of which are not relevant for purposes of the trial. This is when we allow you to call the pastor you've known all your life, and mom who swears her son would never. Okay, we allow character evidence. We allow evidence of what we call prior bad acts, things that are not ordinarily admissible at trial, to assess proper punishment. There are circumstances where punishment should be mitigated. It's an individual situation. Okay, but there's no manslaughter with intent. Okay, intent, you're talking about first-degree murder and possibly second degree. There's no intent for manslaughter because we aggravate the crime up. If she drove the car and intended to hit him, she's a murderer.
Okay.
It's not manslaughter. It's premeditated. Go to my book is page 185. I want to talk about Jennings. Can we turn there? Miss Chinky, did I say it right?
Chinky.
I'm not going to punk out. We'll get it for the end of the semester. I'm sorry. Go to number 9 for me.
Jennings operated a courier service to collect and deliver money. The contract with his customers allowed him a day or so to deliver the money that had been collected. Instead of holding collections until delivered, Jennings made short-term investments with the money. He always made deliveries to the customers on time, but because he kept the profit from the investments for himself, Jennings was prosecuted for embezzlement. Was he guilty?
I have no idea. What do you say?
No, he wasn't.
Okay, tell me why.
I have I'm just gonna bring.
I tell you what, just give me.
I'm just gonna take out some points
Okay.
here. An intent to permanently deprive the owner of the owner's property is essential to the crime of larceny. This intent was apparently lacking, as Jennings had always made payment of the proper amounts when due. So no conduct indicated an intent to deprive the owners permanently of their property. Jennings made an unauthorized use of the property and kept the benefit for himself, but this did not constitute larceny.
Okay. What did they charge him with?
Embezzlement.
Was he an embezzler?
Yeah.
Yes.
He took that money and kept the profit that wasn't even his.
What do you say, Ms. Gaston?
I said yes,
Why?
because they entrusted him with that money to be delivered and he unlawfully invested it in on personal use.
Okay, gang, I want you guys to use the legal language.
Okay.
When Mr. Jennings, or Miss Jennings, we can't tell, initially came into possession of the money, that possession was lawful. The same way it was lawful when I represented Ms. Ragas and we got our $100,000 settlement, we deposited the money in my trust account. I had access to all the money. That was lawful initially. Where things went awry, the same for Jennings, is when he decides to do what?
Go and invest.
Go and invest. Notice, it's not relevant that he pays the people on time when they're due. He's not supposed to invest their money without their consent, permission. He's still an embezzler. Gang, this is the same with Rothstein. A lot of those people made investments and they got paid money. It was still illegal. Because I didn't authorize you to use my money to pay John, I authorized you to use my money to invest. You created a pyramid scheme. Whether I got paid my investment money back or not, it was still unlawfully appropriated. Even if I made whole. You guys understand? I am misusing the funds. Who in this paragraph said, oh, don't worry about it. You go ahead and make short-term investments? No one. Okay? No more than she authorized me to take a dime more than the 25%. That's simple. If I change my example to correlate it to the book's example, and for Ms. Ragas, when that $100,000 is posted, okay, I take 50 grand of that money and go to the casino. I double it. Come back, put it in the trust account, pay her full $75,000, and now I have an extra 50 for myself. I paid her money, right? Well, what's the problem? What if I lost it? Did she authorize me anything over $25,000 I didn't have a right to? So I was playing with my money and her money. Did she ever give me permission to do that? I'm an embezzler. There are a lot of ways you can steal. I'm a thief. It's not predicated on whether I ultimately pay her. The Ponzi schemes go for years because they're able to pay people out, use funds, until one day it falls apart. Those other people have been stolen from the same as the others. Their money was misused, period. Okay, I want you guys to get that, because if I give you something like that next week, don't tell me because I ultimately paid her, I'm not culpable for embezzlement. That's false. I misused her money.
Sir, I got my answer online because I was really reading up about this case. And it said the court negated embezzlement and reinstated Jennings on the charge of grand larceny to the second degree.
Well,
I know what you're saying. I understand what you're saying. No.
Well, here's the problem. Larceny, which if we have time we'll get to today. Larceny is a crime of intent. So there's what we call mens rea. You cannot commit larceny without intending to take the money. And you have to intend to keep it, what we call permanently deprive the person of the money or goods or whatever it is I'm stealing. The term grand larceny just refers to a higher amount of theft. So if I steal a car, because of the value, it's grand larceny. To your point, however, what the court may have said based on the facts of the case was that the initial possession was not lawful. If that's what the court reasoned, it would be larceny. Because in theory, then, he never had a right to the money. And if I'm reading that based on what they gave me, he runs a courier service to collect and deliver money. His initial collection would be lawful in my mind. I don't know all the details of that case, but that's what it would hinge on, the larceny versus embezzlement.
So can I just read out what I have here?
Yeah, go ahead.
It says Century's actions utilizing the cash for its own benefit for the 2 or 3 day period would not violate the statute. In order to be guilty of embezzlement, Century and or its officers who participated in these transactions would have to loan, lease, pledge, pawn, or otherwise encumber property without the consent of the owner thereof. Under the facts and circumstances of this case, deprived seems to be the crucial element. This is what I was getting from
Right, but let me say this to you, Ms. G. I like the way you're thinking, and many of these cases hinge on one fact. If you look at it, his operation is to collect and deliver money.
Right.
The great part for the court is the sentence next. The contract with his customers allowed him a day or so.
Right.
A day or so to deliver the money. If they had said 3 days, on the 4th day he's an embezzler because he doesn't have lawful possession. He's gone beyond the period of lawful possession with day 4 if they gave him 3 days. They don't give a time period. So the court, to my latter point, is wrestling with the lawful possession issue. I mean, that's the crux of it. If you see that, then I'm happy. And was there lawful possession? Which is why by default, you usually see a professional. Because lawyers handle money, trust money for clients. Bankers handle invest funds for clients and so forth. CPAs do taxes. They come into money on behalf of other people. Okay? All right, good. Go over to the last one, which is 14, page 186 on my book. Okay? Howell made long-distance telephone calls through the telephone company's computer-controlled switching system to solicit funding for a non-existent business enterprise. What crimes did Howell commit? Let me repeat it again. Howell made long-distance telephone calls through the telephone companies, meaning a third party, computer-controlled switching system to solicit funding for a non-existent business enterprise. What do you guys say? Did he commit any crime? Yes. I gotta stop calling you down. Tell me your name one more time.
Courtney
What's your last name?
Manat.
Manat. What do you say?
He committed a white collar crime.
Okay.
A white collar crime is generally considered business crime. The type committed without physical threats or acts. And I think specifically he committed a corporate fraud.
Okay.
Because corporate fraud are activities that are done by an individual or company that are dishonest or illegal.
Okay, I love
They're
it.
designed to give the perpetrator an advantage.
I love it. I want to say one more thing about that real quick. Yes.
Racketeering?
Why?
Because he's practicing like abducting and like illegal activity as far as soliciting for made up business.
Okay. I would say this, usually when you are culpable for racketeering, there's a lot of people involved. It's usually an enterprise that you're dealing with. But I like the thought. Yes, sir.
I would say he committed computer crimes.
Okay, like?
Because computer crimes, like it's one committed using a computer or with knowledge of a computer. I said, according to the facts, Howell was using the company's computer control switching system to solicit funding for a non-existent business enterprise. Because the phone system was computer controlled and Howell was using it to make long distance telephone calls in an intent to commit fraud, he committed computer crime.
Okay. I like where you guys are going with that. I just want to make sure we recognize fraud if we see it. Fraud in Florida must be pled with what we call particularity. Don't worry about that, that's kind of civil procedure. But to accuse or allege someone has committed fraud, you must show specific, what we call particular facts. Okay? Because there is no fraud without the purposeful intent to deceive. I have to show that some of those actions warrant that. So for a prosecutor to try someone with fraud, they have a heightened obligation, if you will. Okay? There is no fraud by mistake. Fraud happens with intent. I mean, look at the example. Howell knew what he was soliciting funding for was non-existent. There was no business enterprise that was a legitimate investment on behalf of these people. So any monies garnered were fraudulently obtained. Where would they go? To him. Okay? Now notice it's still a type of theft. It's fraud because the lies are being used to get the money. It can't be embezzlement because he never has lawful possession. Good, I'm getting through. The possession was never lawful. Okay? It's not larceny. A larcenist comes in the room when you guys aren't here and takes your book bag or your purse, takes the money out and goes home. I didn't deceive you to get the money. I just stole it. Here, he's soliciting what? He's using a lie or lies to garner the money. So if you notice, it's all under the umbrella of theft. We're just punishing different ways in which there is to steal. That's really it. Okay, so just think of an umbrella, theft. And under it, you can have petty theft from the candy bar stolen from the store. You can have larceny, the grand larceny to me stealing the car. You can have burglary, which is with force to the extent I enter a home unlawfully and take or intend to take, permanently deprived. Robbery, I'm taking by force. Okay, embezzlement, I took after, subsequent to my lawful possession. I'm still a thief. In every instance, I am stealing. It is just the way in which I stole that differentiates my charge. That's all. It's all theft. Okay? And to Ms. Chief's point, the grand larceny only deals with the volume. I stole over a certain amount. Okay. All right, so here's what we'll do. I want to make sure I collect these. Mr. Jimmy volunteered to do that for me. I'm grateful. And we're going to come in on Wednesday, and we're going to do a final exam review, I suppose, because I want to be fair to you guys before exam 2. And gang, if you look at it, we don't have that much time. We take the exam on Monday, after the review Wednesday. I mean, there's what, 2 weeks left, give or take? It's not a lot of time. We got to cook with grease. The reason I gave the homework assignment is because it lessens what I have to do in class. It means I know that you should be at least at this level. I asked you to give me the definition of those terms, and we did an example of all of them. So I can move forward.
Can you briefly discuss the Dickens Roads?
Oh, yeah, let's go to, what page was it? Back of class, oh, yes. What page was it on in your book?
I just didn't see it.
I usually get like flow.
Page 176.
Guys, go to page 176, just real quick.
Yes, it is.
I was reading 160.
Gang, I'm assuming we all read this. I'm going to go super quick because we only have a minute or two here. What was Scruggs about? You guys, page 176? To be the case involving Dickie Scruggs, whistleblower case, Big Tobacco. Okay. You remember? Do we read this?
No.
I did, it was a lot, a lot.
Okay, I'll tell you what, let's do this. Let's pick back up on Scruggs. I'm not gonna have enough time to do this. Like the Scruggs, I can't do anything. It's just too much.
Yeah, it was
It's too much detail.
Because it goes on.
It goes on.
There's another.
Right, a whole other layer to it.
Yes.
All right.
Just got out too.
Yeah. All right, so guys, listen, we'll pick back up on Wednesday, okay? If I were you, I would very much study what we did today. Just a suggestion. Perfect.